Hello, everybody, and welcome to another episode of Estate Planning TV. I'm your host, Christopher Small. I'm the owner of CMS Law Firm, a Seattle-based estate planning and probate law firm, and this is the internet's most passionate show about estate planning. And enough of the details. Let's get into the show. Hey everybody, Christopher Small here from CMS Law Firm, and today I wanted to hop on here real quick and talk to you about a question that I get actually quite often when I'm doing like estate planning consultations and stuff like that. And people are curious about, or they're worried about, people contesting their wills or contesting their trusts, and having to go through that sort of litigious process and fight through that. And they want to make sure that their wills are good. And so I wanted to hop on here and talk to you about how to sort of prevent that, the ways that people can contest wills, just to let you know, so you have that peace of mind. Because in reality, it's actually quite hard to win a will contest. It's not hard to contest the will, but to do that, somebody's gonna have to pony up some cash. So what I always tell everybody is, look, I can help you make sure that there's a very, very, very low possibility that someone contests your will or contests your trust. But I cannot prevent it 100%, because if somebody wants to pay an attorney to go and contest a will and just sort of be out that cash, then they can do that. They probably won't win. And if they talk to any reputable attorney who looks at the documents and looks at the facts, they should tell the person that they won't win, but that doesn't mean that they won't go after it anyway. You know, when family and money get together, all sorts of crazy things can happen. So I can't guarantee you 100% that it won't happen, but I can guarantee you with a very, very, very high probability that it won't happen. And here's why. There are really only three ways that someone can contest a will. The first reason is if it's not executed properly. What that means is it's not signed properly. It's not notarized properly. It doesn't have the proper witnesses that it's supposed to have, right? So if it's just not sort of signed and done and executed properly, it would make that will invalid, just like any other document. If it didn't have a signature on it, it wouldn't be any good. That's number one. Number two is if the person that's creating the will doesn't have the capacity to do that, to create the will, which means basically they're not in their right mind. They don't have their faculties about them to know that they are executing a will, to know that they are giving their things to someone, to know that they are appointing people into certain positions for them. If they don't have the mental capacity to do that at the time they are signing the documents, then that is a valid reason to contest a will. So that's number two. The third reason is duress. So if you are signing a will and somebody has got a gun to your head and they are making you sign the will, that would be a situation that would invalidate that will, okay? Now, there are all sorts of different levels of duress. There are all sorts of different levels of influence. So it's sort of important to make sure that those situations are handled if they appear to be present. But in most cases, with most people creating their estate plan, creating their will, their trust, all that kind of stuff, you're not gonna have a lot of these situations come into the picture. Most people are of sound mind. Most people are creating their will of their own free will. And then when you come to the office, we make sure all the documents get executed properly, okay? So that's it. It's really, really important to remember that just because somebody is grumpy about not getting what they think is their fair share, or grumpy about what someone else is getting, those are not valid reasons to contest a will. Okay, that will not hold up in court. No attorney is going to sort of submit paperwork with that as the basis for contesting the will. All right, so that's it. Hopefully this sort of puts some of your fears to rest, and you can now go on and create your will and your estate plan and have the comfort of knowing that everything is taken care of. All right, that's it. Now, my name is Christopher Small again with CMS Law Firm. If you know someone that could use this message, that's curious about this, please share this video with them. If you like it yourself, if you thought it was great, that's wonderful. Hit the like button below, leave me a comment, If you have questions, leave comments here or ask questions. That'd be great. I'd be happy to answer them. And that's it. Plan on being here a lot more for these videos, so hopefully you're checking back in. If you know anybody that's interested in this stuff, then have them follow the page or whatever, and that's it. So somebody's joined on, and so hello there. But that's it, everybody. So thank you so much for your time, and I will talk to you again soon. Thank you again for listening to Estate Planning TV, or watching it, depending on how you're here. If you are listening to this on iTunes and you don't want to miss another episode, please hit the subscribe button. If you're watching me on YouTube, please hit the subscribe button. If you are watching me on Facebook or anywhere else, please hit the like button, leave me a comment, let me know if you enjoyed this video, and please, 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 the one way that you can pay this forward, if you know someone that could use this information that needs help with estate planning, please just share this with them, right? This is all helpful information. My goal here is to help everyone make informed decisions, to get the things done that they need to do to protect their family, to protect their assets, to protect their legacy. All right? Once again, I'm Christopher Small with CMS Law Firm. Hope you have a great day, and I will talk to you again soon.